The notice was taped to my door at 2 in the morning, and the security camera timestamp proved it. I moved to Redmond, Washington 3 months ago for a pest control job that pays well but requires total reliability, and the Canyon Springs Village Association has been manufacturing violations ever since. The townhome complex is a shared wall maze where every sneeze draws a complaint, and Cynthia Parker runs the social committee like a surveillance state. She goes by Janet to neighbors, and her favorite line is the HOA has the authority, whether you like it or not. My job is on probation until March, meaning I cannot miss a single shift for HOA hearings or risk termination, and Janet knows it. The notice claimed my security camera violated privacy rules, which was rich, because the camera caught her standing on my porch in a purple parka and cream earmuffs, holding a flashlight and a clipboard at 2 in the morning. The temperature was dropping fast, and any meltwater from the afternoon snowmelt would refreeze into black ice within hours, making the already treacherous walkways lethal. I pulled my black parka tighter and stepped outside to check the camera housing. The camera was mounted under the eave, angled to cover my porch and the shared walkway. It was the same model half the complex uses, approved in the original HOA guidelines from 2019. I pulled the footage and saved 3 clips, Janet arriving at 1:58, Janet taping the notice at 2:03, and Janet leaving at 2:06. She looked directly at the camera twice. I forwarded the clips to my phone and added them to a folder I had been building since November. The folder also included copies of board meeting minutes from October, which stated that doorbell cameras and porch security devices were explicitly allowed as long as they did not record inside neighboring units. Janet had signed those minutes as secretary. The contradiction was not an accident. It was part of a pattern. I went back inside and made coffee. The notice cited Rule 14-7, unapproved exterior modifications, but the camera had been installed by the previous owner in 2021 and was listed in the disclosure documents I signed at closing. I pulled the closing packet and photographed the page. Then I checked the HOA portal and found a second notice posted at 2:13 claiming my winter boot scraper mat was an unapproved porch item. The mat was black rubber, 18 inches square, and sat centered on my concrete porch. It was identical to the ones on 4 other porches in my building. I photographed those porches from the sidewalk, timestamped the images, and added them to the folder. The escalation was deliberate. Janet was not enforcing rules. She was manufacturing a paper trail. At 6 in the morning, my phone buzzed. A vendor I did not recognize was scheduled to inspect my porch at 7:30 for code compliance. The email came from the management company, but the work order was vague, listing only exterior assessment and photographic documentation. I called the management company and got voicemail. I called the vendor and got a receptionist who said the inspection was mandatory and refusal would result in a fine. I asked who requested it. She said the social committee. I said I would be there. The vendor arrived at 7:25 in a white panel van with no company logo. He was younger than me, maybe mid-20s, wearing a reflective safety vest and carrying a tablet. He apologized immediately. He said he was supposed to document my porch setup and write a report for the HOA, but he had been hired for 3 other units this week and all of them were the same thing, residents who had complained about Janet. He said he was not writing anything unless he saw an actual code violation. I showed him the boot mat and the camera. He took 2 pictures, said everything looked fine and left. I asked his name. He said Derek, and he told me to watch my back because the social committee was trying to build cases against 4 or 5 people at once. I went to work. My route that day covered North Redmond and Kirkland, 18 service calls for rodent monitoring and exclusion inspections. I keep detailed logs for every call, noting entry points, bait placements, and client concerns. The discipline helps at work, and it was helping now. I started a new log for the HOA situation, dates, times, notices, witnesses, and every piece of evidence. By noon, I had logged 6 entries. By 5, I had printed the October meeting minutes and highlighted Janet's signature. When I got home, there was a new notice on my door. This one claimed I was prohibited from using the shared dumpster enclosure after 8 at night due to noise complaints. The dumpster was 50 yards from my unit, and I had used it exactly twice in 3 months, both times before 7. I checked my trash pickup log. My phone calendar confirmed I had taken trash out on November 10th at 6:42 and December 3rd at 6:15. I screenshot the calendar entries and added them to the folder. Then I checked the HOA portal again. A new rule proposal was listed for the January meeting. Exterior cameras must be approved individually by the board, and any existing cameras installed before the proposal would require retroactive permits. The proposal was submitted by Janet. I called my neighbor Marcus, who lived 2 doors down. He was the neighborhood security guard hired by a different property management company to patrol 3 complexes in the area, including Canyon Springs. He was tired of being used as muscle by HOA boards that wanted enforcement without accountability. He said Janet had asked him twice in December to knock on my door and remind me about quiet hours. But he had refused because there was no actual violation. He also said the management company was getting nervous about Janet because 2 residents had filed formal complaints in November and the complaints had disappeared from the portal. He suggested I email the board directly and copy the management company on everything. I drafted an email. I attached the camera footage, the closing documents, the October meeting minutes, and the photos of identical boot mats on other porches. I kept the tone calm and factual. I wrote that I was confused by the notices since my camera and mat were both compliant with current rules and identical to setups approved elsewhere in the complex. I asked for clarification and requested a written response within 5 business days. I copied the management company, the board president, and the treasurer. I did not mention Janet by name. I sent it at 8:30. At 9:15, my phone rang. It was Janet. She did not introduce herself. She said the board had received my email and found it inappropriate. I asked what was inappropriate about requesting clarification. She said I was creating a hostile environment and the board was considering a formal cease and desist letter. I asked what I was supposed to cease. She said contacting board members directly. I pointed out that the HOA bylaws require residents to submit concerns in writing to the board. She said I was twisting the rules. I said I was following them. She said the HOA has the authority whether you like it or not. I said I understood and I would wait for the written response. She said I should be careful because she could make my insurance hear about this. I asked what she meant. She hung up. I saved the call log. Then I opened the bylaws and read Section 12, which covered dispute resolution. Residents were required to submit complaints in writing to the board. The board was required to respond in writing within 10 business days. If the board did not respond, the resident could request a hearing. If the hearing did not resolve the issue, the resident could pursue mediation or legal action. I highlighted the section and added it to the folder. Then I Googled Cynthia Parker Canyon Springs HOA. The third result was a neighborhood forum post from 2023, asking if anyone else had received confusing notices from the social committee. The thread had 42 replies. Most of them mentioned Janet. The next morning, I got a response from the board president. He said my email had been forwarded to the Rules Committee for review, and I would receive a decision within 30 days. He did not address any of my questions. I replied and asked if the 30-day timeline was in addition to the 10-day response requirement in the bylaws. He did not reply. I forwarded the exchange to Marcus and asked if he had ever seen the board ignore the bylaws this blatantly. He said yes, constantly, and he suggested I start attending board meetings. The January meeting was scheduled for the 15th at 7 in the evening in the clubhouse. I marked my calendar. Then I checked the portal again. The camera permit proposal had been moved up to a vote for the 15th. A second proposal was added. Residents with outstanding violations would be banned from using amenities, including the gym, pool, and clubhouse, until violations were resolved. The proposal did not define outstanding or resolved. I screenshot the portal and added it to the folder. On the 10th, I got a text from an unknown number. It said a compliance inspector would be visiting my unit on the 12th at 9 in the morning to document porch conditions. I replied and asked who sent the text. No response. I called the management company and asked if they had scheduled an inspection. They said no. I asked if the HOA could schedule inspections without management company approval. The representative said technically yes, but it was unusual and they would look into it. I said I would be recording the inspection. She said that was my right. On the 12th, no inspector showed up. At 9:30, I got an email from Janet saying the inspection had been postponed due to weather. It had not snowed in 2 days. I replied and asked for the new inspection date. No response. At noon, I got a second text from the same unknown number saying the inspection was rescheduled for the 14th at 8 in the morning. I replied and said I would be at work at 8. The response came back immediately. Refusal to allow inspection may result in fines per Section 9-4. I checked Section 9-4. It covered emergency inspections for safety hazards, and it required 24 hours written notice and management company approval. I screenshot the exchange and forwarded it to the management company with a copy of Section 9-4 highlighted. The representative replied within an hour, saying the HOA had no authority to schedule inspections without cause and she would contact the board. That afternoon, a water delivery truck splashed slush onto my porch steps while backing into the turnaround. The slush froze within 20 minutes, coating the bottom 3 steps in a sheet of clear ice. I salted the ice immediately and swept the excess slush into the planter box. At 4:30, I looked out the window and saw Janet standing on the sidewalk with her phone, taking pictures of my steps. I grabbed my phone and stepped outside. She did not look up. I asked if there was a problem. She said the ice was a hazard and the HOA would be filing a report. I pointed to the salt crystals still visible on the steps. She said salt was not sufficient and I was required to remove all ice within 2 hours of formation per the winter maintenance addendum. I asked to see the addendum. She said it was posted in the clubhouse. I said I would check the portal. She said the portal was not always current. I said that sounded like a management company problem. She took 3 more pictures and walked away. I went to the clubhouse. The winter maintenance addendum was not posted. I asked the front desk attendant if there was a binder with current rules. She said the binder was only updated once a year and the last update was in March. I asked if she had seen a winter maintenance addendum. She said no. I thanked her and left. When I got home, there was a new notice on my door: failure to maintain safe conditions, photographic evidence attached, fine pending board review. The attached photo showed my steps with visible ice, but the timestamp was 4:32, 2 minutes after I had salted. The salt crystals were cropped out of the frame. I printed the notice and the photo. Then I pulled my own photos from 4:35, showing the salt spread across the steps and the empty salt container on the porch. I also pulled the delivery truck footage from my camera, showing the splash and the immediate salting response. I added everything to the folder. Then I checked the HOA portal one more time. A new notice was posted at 5:15, emergency board meeting on the 13th at 6, to discuss safety violations and amenity access restrictions. The emergency meeting was not on the calendar. I emailed the board president and asked if the meeting was open to residents. He replied at 10 that night and said the meeting was executive session only. I checked the bylaws. Executive sessions were allowed for personnel issues, legal matters, and contract negotiations. Safety violations were not listed. I replied and quoted the bylaw section. No response. On the 13th, I parked across the street from the clubhouse at 5:45 and waited. Janet arrived at 5:50 in her purple parka, carrying a leather portfolio. The board president arrived at 5:55. 2 other board members arrived together at 6. The treasurer did not show. I waited until 6:15, then walked to the clubhouse door. The front desk attendant said the meeting was closed. I asked if minutes would be posted. She said usually, but sometimes they were delayed. I asked how long. She said it depends. I thanked her and left. At 7:30, I got an email from the management company. The board had voted to suspend my amenity access pending resolution of 3 outstanding violations: the camera, the boot mat, and the ice hazard. The suspension was effective immediately. I replied and asked for a copy of the vote and the meeting minutes. The representative said minutes were not yet available, but the board had provided a summary. I asked when minutes would be available. She said within 14 days per standard policy. I pointed out that the board had voted to restrict my property rights without providing documentation or an opportunity to respond. She said I could request a hearing. I requested a hearing. The next available date was February 3rd. I asked if the amenity suspension would remain in effect until the hearing. She said yes. I asked if I could attend the January 15th regular meeting to address the board directly. She said residents were allowed 3 minutes during open comment. I said I would be there. That night, I went through the folder and organized everything chronologically. I had 23 pieces of evidence: camera footage, photos, emails, text messages, bylaws, meeting minutes, and vendor statements. I printed everything and put it in a binder with tabs. Then I made a second binder and added a cover letter summarizing the timeline and the contradictions. I wrote that I was not disputing the HOA's authority, but I was asking for consistency and transparency, and I was willing to resolve any legitimate concerns through the proper process. I kept the tone neutral. On the 14th, I got a text from Marcus. He said Janet had asked him to file a report about my porch ice, and he had refused because the ice was from a delivery truck and I had salted immediately. He also said Janet had tried to get him to write up 2 other residents for snow removal delays, but both residents had cleared their walks within the required 24 hours. He said he was documenting everything because he was worried Janet was setting people up. I called him and asked if he would be willing to provide a statement. He said yes, but only if it was formal and on record, because he did not want Janet retaliating against his employer. I said I would draft something and send it over. He said he would also check if any other guards had been pressured. I thanked him. That afternoon, I drafted a witness statement form with spaces for date, time, incident description, and signature. I sent it to Marcus and asked him to fill out one for each time Janet had asked him to file a false report. He sent back 3 completed forms by evening. Each one was detailed and specific. I added them to the binder. On the 15th, I left work early and drove to the clubhouse. The parking lot was half full. I recognized a few cars from my building. Inside, the meeting room was set up with a folding table at the front and rows of chairs facing it. Janet sat at the table on the left, wearing the same purple parka. The board president sat in the center. The vice president sat on the right. About 20 residents were scattered in the chairs. I took a seat in the back row and set the binder on my lap. The meeting started at 7. The president read through standard business, budget approval, landscaping contract renewal, pool maintenance schedule. At 7:30, he opened the floor for new business. Janet raised her hand immediately. He called on her. She stood and said the social committee had identified multiple safety and compliance concerns in recent weeks, and the board needed to take immediate action to protect property values. She said several residents were ignoring rules, creating hazards, and refusing to cooperate with inspections. She did not say my name, but she looked directly at me twice. The president asked for specifics. Janet said she had documented cases involving unauthorized cameras, unapproved porch items, and ice hazards, and the board had already voted to suspend amenity access for 1 resident pending a hearing. A woman in the 3rd row raised her hand and asked which resident. The president said he could not discuss individual cases in open session. The woman said that seemed convenient. Janet's face flushed. She said the board had followed proper procedure and the resident in question had been given multiple opportunities to comply. I said nothing, because silence makes people talk. Another resident raised his hand and asked if the board had updated the winter maintenance rules. The president said no. The resident said he had received a notice about ice removal timelines that were not in the portal. Janet said the notice was based on the standard of care expected in a managed community. The resident said that was not a rule. Janet said the HOA has the authority whether you like it or not. 3 people in the front row turned and stared at her. I made a note. The president moved to the camera permit proposal. He said the board was concerned about privacy and wanted to require individual permits for exterior cameras going forward. A man in the 2nd row said his doorbell camera had been installed in 2020 and was listed in the guidelines as approved. The president said the new proposal would grandfather existing cameras but require annual renewals. The man said that was insane. The vice president said the proposal was still in draft and the board welcomed input. Janet said input was appreciated, but the board had the final say. The man stood up and said he was tired of selective enforcement and arbitrary rule changes, and if the board wanted to fine him for a camera that was legal when he installed it, he would fight it. Janet said that was his right, and the board would proceed accordingly. The man sat down. I made another note. At 8, the president opened public comment. I raised my hand. He called on me. I stood and said I appreciated the opportunity to speak. I said I had received multiple notices in the past 2 weeks, and I wanted to clarify the facts before the hearing in February. I said my security camera was installed by the previous owner in 2021, disclosed at closing, and compliant with the guidelines signed by the board in October. I said my boot mat was identical to mats on 4 other porches in my building. I said the ice on my steps was caused by a delivery truck and salted within minutes. I said I had documentation for all of this, and I was happy to provide it to the board. Janet interrupted and said I was wasting everyone's time. I said I had 2 minutes left. The president told her to let me finish. I said I was also concerned about the process, because I had been suspended from amenities without a hearing, in violation of the bylaws. I said I was not asking for special treatment, just consistency. I said thank you and sat down. Janet stood immediately. She said I was misrepresenting the facts and the board had acted appropriately. She said my camera was pointed at neighboring units, my mat was blocking the walkway, and my ice was a lawsuit waiting to happen. I did not respond. The president said the hearing would address my concerns and the board would review the evidence at that time. Janet said the evidence was clear and the board had already made its decision. The vice president looked uncomfortable. The president said the meeting was adjourned. I stayed in my seat while people filed out. A woman from the 4th row stopped and said she had received a similar notice about her doorbell camera and was told to remove it or face a fine. She asked if I was going to fight it. I said yes. She said she would too, and she asked if I had a lawyer. I said not yet, but I was considering it. She gave me her number and said to keep her updated. 2 other residents stopped and said the same thing. By the time I left, I had 4 numbers and a group text thread started. That night, I went through the October meeting minutes again. The minutes listed a vote on the camera guidelines, 4 in favor, 1 abstention. The abstention was the treasurer. I pulled the November minutes and found a note that the treasurer had resigned effective November 30th due to personal reasons. The December minutes listed Janet as interim treasurer. I checked the portal for the treasurer's resignation letter. It was not posted. I checked the bylaws. The treasurer was required to submit a written resignation to the board, and the board was required to post it within 10 days. I emailed the management company and asked for a copy of the resignation letter. The representative said she would check and get back to me. On the 16th, I got a reply. The management company had no record of a resignation letter. They said the board had verbally informed them of the treasurer's departure in early December, but no formal documentation had been provided. I asked if that was normal. She said no. I asked what happened to the treasurer's records. She said the board was supposed to transfer them to the interim treasurer. I asked if that had happened. She said she did not know. I thanked her and forwarded the exchange to the group text thread. One of the residents replied and said the former treasurer lived 3 buildings over and she would ask around. On the 17th, the resident texted back. She said the former treasurer, a man named Bill, had not resigned. He had been forced out after questioning a series of unapproved expenses in the social committee budget. He had asked for receipts, and Janet had accused him of harassment. The board had voted to remove him in a closed session, and Janet had taken over his duties. Bill had threatened to sue, but his lawyer told him it would cost more than it was worth. The resident said Bill still had copies of the financial records, and he was willing to talk. I met Bill at a coffee shop in downtown Redmond on the 18th. He brought an accordion folder full of printed spreadsheets and bank statements. He said Janet had been running the social committee budget like a personal slush fund since 2022, approving expenses for events that never happened and vendor contracts that had no deliverables. He said he had flagged over $12,000 in unexplained charges between January and October of last year, and when he asked Janet for receipts, she accused him of creating a toxic environment. He said the board had taken her side without reviewing the evidence, and he had been removed in a 4-to-1 vote. The vice president had been the only no vote. He said he had tried to escalate to the management company, but they said it was an internal board matter. He said he was done fighting, but he would hand over the records if I was willing to use them. I took the folder. Inside were copies of every social committee transaction from 2022 through October 2024, with highlighted discrepancies and handwritten notes. The notes pointed out duplicate payments, vendors with no online presence, and event budgets with no corresponding event photos or announcements. One entry was for a fall festival in September 2024 that was budgeted at $1,800, but no festival had been held. Another was for a landscaping consultation in July 2024 for $2,200, but the landscaping had not changed. Bill said he had contacted 3 of the vendors, and 2 of them had no record of working with the HOA. The third had done work, but the invoice was for $600, not the $1,800 the HOA had paid. I asked if he had reported this to the management company. He said yes, in October, and they had forwarded it to the board. The board had replied that the treasurer's concerns were based on incomplete information and the matter was closed. He had asked for a formal audit. The board had refused. He had asked to see the bank statements. Janet had said the statements were confidential. He had pointed out that treasurers were required to provide financial reports at every meeting per the bylaws. She had said he was no longer treasurer. 2 weeks later, he was out. I asked if he would testify at my hearing. He said no, because his lawyer had advised him to stay clear of the HOA unless subpoenaed. But he said I could use the records however I wanted, and if the board tried to retaliate, he would go to the state attorney general. I thanked him and left. That night I went through the financial records. The pattern was clear. Janet was approving payments to vendors. The vendors were either fake or overbilled, and the excess was disappearing. I cross-referenced the vendor names with state business registrations. 3 of the vendors did not exist. 2 were registered to residential addresses in Bellevue and Tacoma. 1 was registered to a P.O. box in Redmond with Janet's name listed as the agent. I screenshot the registration page and added it to the folder. I now had 2 cases. The harassment case, based on selective enforcement and contradictory notices, and the fraud case, based on missing funds and fake vendors. I decided to keep them separate until the hearing. The harassment case was airtight and easy to prove. The fraud case was explosive but required more corroboration. I needed the bank statements. On the 19th, I filed a public records request with the management company, asking for all financial records, meeting minutes, and correspondence related to the social committee budget from 2022 to present. The management company replied that HOA records were not subject to public records requests, but owners had a right to inspect records per the bylaws. I replied and said I was requesting inspection. They said I needed to submit a written request to the board and schedule an appointment. I submitted the request that night. The board did not respond. I followed up on the 22nd. No response. I followed up again on the 25th and copied the management company. The representative replied and said the board was required to respond within 10 days, and if they did not, I could escalate to the state. I asked what escalate meant. She said I could file a complaint with the Washington State Attorney General's office or hire a lawyer to compel compliance. I said I would wait until the 10th day. On the 28th, I got an email from Janet. She said my records request was overly broad and burdensome, and the board was denying it. I replied and quoted the bylaw section that granted owners the right to inspect financial records. She said the bylaws did not require the board to fulfill fishing expeditions. I said I was requesting standard budget documents, not fishing. She said the request was denied, and if I continued to harass the board, I would face additional consequences. I forwarded the exchange to the management company and asked if the denial was legal. The representative said no, and she would contact the board again. On the 30th, the management company sent a letter to the board on my behalf, stating that my records request was proper and the board was required to comply within 5 business days or face a formal complaint. Janet replied to the management company and said the board would provide a partial response by February 5th after the hearing. I replied and said the hearing was on the 3rd, and I needed the records before then to prepare. No response. I decided to move forward without the bank statements. I had enough evidence to prove selective enforcement, and I had Bill's records to suggest fraud, even if I could not prove it directly. I prepared a presentation, timeline, exhibits, witness statements, and a summary of bylaw violations by the board. I kept it under 10 minutes. I also prepared a 1-page handout with the key evidence, and I printed 30 copies. On February 1st, I got a text from the unknown number again. It said a tow truck had been dispatched to remove my vehicle from the guest parking lot due to unauthorized overnight parking. I did not park in the guest lot. I went outside and checked. My truck was in my assigned spot, clearly marked with my unit number. I took a photo and replied to the text, saying my vehicle was in my assigned spot and no tow was authorized. The reply came back, error in address, tow canceled. I screenshot the exchange and added it to the folder. At noon, I drove to the clubhouse to check my mailbox. The mailbox cluster was in the center of the complex, a set of locked boxes arranged in a three-sided rectangle with a trash can in the middle. When I arrived, Janet was standing near the trash can, talking to a tow truck driver. The driver was holding a clipboard and pointing at a silver sedan parked 2 spots from the mailboxes. I recognized the sedan. It belonged to the woman from the meeting who had given me her number. I walked over. Janet saw me and her expression hardened. I greeted the driver and asked what was happening. He said he had a work order to tow the sedan for expired registration. I asked to see the work order. He showed me. It listed the vehicle plate, the lot number, and the reason, expired tabs per HOA policy. I looked at the sedan. The tabs were current, expiring in April. I pointed this out to the driver. He looked at the plate again and frowned. He said the work order must be wrong. Janet said the work order was correct and the vehicle was in violation. The driver said the tabs were clearly valid. Janet said the HOA has the authority whether you like it or not, and the vehicle needed to be removed. The driver said he was not towing a legal vehicle. Janet said she would call his supervisor. The driver said go ahead. He walked back to his truck and drove away. Janet turned to me and said I was interfering with HOA business. I said I was checking my mail. She said I was harassing her. I said I had not spoken to her until she made a false claim to the tow driver. She said she could make my insurance hear about this. I said I was recording the conversation. She walked away. I checked my mail and then went to the woman's unit and knocked. She answered, and I told her what had happened. She said she had received a notice that morning claiming her registration was expired and her car would be towed if not removed by noon. She had checked her tabs, confirmed they were current, and ignored the notice. She asked if Janet was trying to tow her car as retaliation. I said it looked that way. She said she was done being polite and she would be at the hearing. That night I emailed the group text thread and told everyone what had happened. 2 more residents replied and said they had received fake notices in the past week, one for a lawn ornament that did not exist and one for a noise complaint during hours when the resident was out of town. Both residents said they were coming to the hearing. I replied and said I was bringing evidence and if anyone else had contradictory notices or records, they should bring them too. 3 people said they would. On February 2nd, I finalized my presentation and printed the handouts. I also prepared a short opening statement. I was not here to attack anyone, I was here to ask for fairness. And I had evidence that the rules were being applied inconsistently. I practiced it twice and timed it at 40 seconds. I wanted to leave time for the evidence. The hearing was scheduled for 6 on the 3rd. I arrived at 5:45 with the binder and the handouts. The board was already seated, President, Vice President, and Janet. The management company representative was on a video call from a laptop at the side of the table. There were no other residents. I asked if the hearing was open to observers. The president said no. I asked if I could record. He said no. I asked if minutes would be taken. The management company representative said yes, she was taking notes. I sat down. The president said the hearing was to address 3 violations: unauthorized camera, unapproved porch item, and failure to maintain safe conditions. He said I would have 10 minutes to present my case, and the board would ask questions afterward. I said I understood. He told me to begin. I opened the binder and started with the camera. I showed the closing documents, the installation date, and the October meeting minutes with Janet's signature approving doorbell cameras and porch security devices. I showed the camera angle which covered only my porch and the shared walkway, not neighboring units. I showed the footage of Janet taping the notice at 2 in the morning, proving the camera was functional and properly positioned. Janet interrupted and said the guidelines did not specifically authorize my model. I said the guidelines did not prohibit it either, and the October minutes confirmed that cameras were allowed as long as they did not record inside neighboring units. She said the board had discretion to interpret the rules. I said discretion was not the same as contradiction. The president told us both to stay on topic. I moved to the boot mat, I showed the photos of identical mats on 4 other porches, all in my building, all visible from the sidewalk. I asked if those residents had also been cited. Janet said the other mats were smaller. I measured my mat on my phone and showed the photo metadata, 18 inches. I pulled up one of the other mats and showed the metadata, 18 inches. Janet said the issue was placement, not size. I asked what the correct placement was. She said mats were required to be flush with the wall. I showed a photo of my mat, which was centered on the porch and flush with the wall behind it. She said it was still a tripping hazard. I asked if the other mats were also hazards. She did not answer. I moved to the ice. I showed the delivery truck footage, the salting response, and the timeline. I showed Janet's photo with the cropped salt crystals, and I showed my photo 2 minutes later with the salt visible. I said the ice had formed at 4:28 and was salted by 4:33, well within any reasonable response time. Janet said I was required to prevent ice formation, not just treat it. I asked how I was supposed to prevent a delivery truck from splashing. She said I should have been monitoring my porch. I said I was at work. She said that was not the HOA's problem. I said selective enforcement was the HOA's problem, and I had evidence of a pattern. I pulled out the vendor statement from Derek, the inspector who had refused to write a false report. I read his statement aloud. He had been hired to document violations at my unit and 4 others, all residents who had questioned Janet, and he had found no violations at any of them. Janet said the vendor was lying. I said the vendor had no reason to lie, and I had his contact information if the board wanted to follow up. The president said he would take it under advisement. I said I also had statements from the neighborhood security guard documenting 3 times Janet had asked him to file false reports. Janet's face went white. I handed the statements to the president. He read them silently. The vice president leaned over and read with him. Janet said the guard was disgruntled and unreliable. I said the guard worked for a third-party company and had no stake in the dispute. The president set the statements down and said the board would need time to review. I said I had one more thing. I said I had requested financial records on the 19th, and the board had denied the request in violation of the bylaws. I said I was renewing the request now, on the record, and I expected compliance within 5 days. Janet said the request was still denied. I said denial was not an option under state law. The management company representative spoke up and said I was correct, and the board was required to provide access to financial records upon request by an owner. Janet said the records were confidential. The representative said no, they were not. The president said the board would provide a response by the 10th. I said I would hold them to that. The president said the hearing was complete and the board would issue a decision within 14 days. I asked if my amenity suspension would be lifted pending the decision. He said no. I said that was a violation of due process. He said the board had discretion. I said I would be filing a formal complaint with the state if the suspension was not lifted by the end of the week. The management company representative said she would follow up with the board offline. The president adjourned the hearing. I collected my binder and left. The next morning, I filed a complaint with the Washington State Attorney General's Office, Consumer Protection Division. I attached the records request denial, the amenity suspension notice, and the bylaws. I also attached the financial records Bill had given me, with a cover letter explaining the discrepancies and the forced removal of the treasurer. I requested an investigation into both the bylaw violations and the potential fraud. The confirmation email said I would receive a response within 30 days. On the 5th, the management company called. The representative said the board had voted to lift my amenity suspension, effective immediately, and to approve my records request. She said the financial records would be available for inspection on the 9th at the clubhouse between 9 and noon. I asked what had changed. She said the board had received additional information that warranted reconsideration. I asked what information. She said she could not discuss it. I thanked her and hung up. On the 9th, I went to the clubhouse at 9. The front desk attendant directed me to a conference room. Inside was a folding table with 3 banker boxes. A management company staff member was sitting in the corner with a laptop. She said I had 3 hours to review the records and I could take notes but not remove any documents. I said I understood. I started with the most recent box, covering 2024. The social committee budget was in the front. I went line by line, cross-referencing with Bill's notes. Every discrepancy he had flagged was confirmed. Duplicate payments, fake vendors, events that never happened. The Fall Festival entry was there, showing an $1,800 payment to a company called Evergreen Event Services. I Googled the company. No results. I checked the state business registry. No registration. I made a note. I moved to the landscaping consultation entry. The payment was to a company called Summit Landscape Design, $2,200. I Googled it. The company existed, but their website showed commercial projects only, office parks, shopping centers, municipal contracts. I called the number. A receptionist answered. I asked if Summit had done any work for Canyon Springs Village Association. She put me on hold, then came back and said no. They had no record of that client. I thanked her and hung up. I kept going. By 11, I had documented 8 fake payments, totaling $19,000. I took photos of every page with my phone. The staff member did not object. At 11:30, I found a payment to a vendor called Parker Consulting Group for meeting facilitation services, billed monthly at $500 from March through December 2024. I Googled Parker Consulting Group. The registration address was a P.O. box in Redmond. The agent was Cynthia Parker. I took 6 photos and made a note in all caps. At noon, the staff member said my time was up. I thanked her and left. I sat in my truck and went through the photos. I had enough to prove fraud, but I needed corroboration. I called Bill and told him what I had found. He said he was not surprised, and he asked if I was going to the state. I said yes, and I was also going to email every homeowner in the complex. He said that would get their attention. I asked if he would back me up if the board tried to claim the records were fake. He said yes, because he had kept his own copies, and they matched. I spent the afternoon drafting an email. I kept it factual and calm. I wrote that I had inspected the HOA financial records as allowed by the bylaws, and I had found significant discrepancies that required immediate board attention. I listed the 8 fake payments, the unregistered vendors, and the Parker Consulting Group entries. I attached photos of the records and the business registrations. I wrote that I was not making accusations, but I was asking the board to conduct an independent audit and provide a full accounting to the membership. I wrote that transparency was essential to maintaining trust, and I hoped the board would address these concerns promptly. I copied the management company, the board, and every email address listed in the resident directory. I sent it at 6 on the 10th. By 8, my phone was ringing. The first call was from the woman with the doorbell camera. She said she had gone through the records photos and found a payment to a vendor she recognized, a catering company that had supposedly provided food for a summer barbecue in 2023. She had attended the barbecue, and the food had been potluck, not catered. She said the payment was for $1,100. I added her statement to the folder. The second call was from a resident I had never met. He said he was on the board in 2022 and had been voted out after questioning a social committee expense. He said Janet had called him a troublemaker and the board had refused to renew his term. He said he still had emails from that time showing Janet pressuring him to approve expenses without documentation. He asked if I wanted copies. I said yes. By 10, I had received 14 emails and 6 calls. Most were supportive. 2 were angry, saying I was causing drama and hurting property values. 1 was from the vice president. He said he had reviewed my email and the attachments, and he was requesting an emergency board meeting to discuss next steps. He said he had been uncomfortable with Janet's actions for months, but he had not had enough evidence to challenge her until now. He asked if I would attend the meeting and present the findings. I said yes. The emergency meeting was scheduled for the 12th at 7. The vice president said it would be open session and all residents were invited. I forwarded the invitation to the group text thread. 8 people said they would come. On the 12th, I arrived at 6:45. The parking lot was packed. Inside, every seat was full, and people were standing along the walls. Janet was at the front table, sitting alone. The president and the other board member were absent. The vice president was standing near the door, talking to the management company representative. He saw me and waved me over. He said the president had resigned that morning, effective immediately, and the other board member had resigned an hour ago. He said he was the only board member left, and he was not sure the meeting was even valid. The management company representative said the bylaws allowed a single board member to call a meeting if a quorum could not be formed, and the membership could vote to install interim leadership. The vice president said he would open the floor and let the residents decide. The meeting started at 7. The vice president explained the situation, 2 resignations, a financial investigation underway, and a decision needed on how to proceed. He said he had invited me to present the evidence, and after that, the floor would be open for discussion. He called on me. I stood and distributed the handouts. Then I walked through the timeline, the fake notices, the forced removal of the treasurer, the records request denial, and the financial discrepancies. I showed the vendor registrations, the fake company listings, and the Parker Consulting Group connection to Janet. I kept my tone calm and factual. I said I was not here to attack anyone, but the evidence suggested a serious problem, and the membership deserved answers. Janet stood up. She said I was lying and the records were incomplete. I asked which part was a lie. She said the vendors were real and the payments were legitimate. I asked if she could provide receipts. She said receipts were confidential. The vice president said receipts were not confidential and the board was required to maintain them. Janet said I was twisting the facts to cover my own violations. I said my violations had been disproven at the hearing and the board had lifted my suspension. She said the suspension was lifted as a courtesy, not an exoneration. I said the hearing minutes would show otherwise, and I would be happy to wait for the management company to post them. A man in the 3rd row stood and said he had received a fake notice about a fence repair that was never needed, and he had paid a $200 fine before realizing the notice was bogus. He asked if he could get a refund. Another woman stood and said she had been fined for a late fee that was applied incorrectly, and when she disputed it, Janet had threatened to put a lien on her property. A 3rd resident said Janet had told him his shed was unapproved, but the shed had been installed in 2018 and was on the original site plan. The room erupted. People were standing, shouting questions, demanding answers. Janet tried to speak over them. The vice president banged on the table and called for order. When the room quieted, the vice president said the board, or what was left of it, would suspend all pending violations pending an independent audit. He said the management company would hire a forensic accountant to review the financials, and the results would be posted within 60 days. He said any fines paid in the past year could be disputed and refunded if the violations were found to be improper. He said the membership would vote tonight on interim board members to fill the vacant seats. Janet stood and said the vote was invalid because there was no quorum. The vice president said the bylaws allowed emergency appointments by majority vote of attending members. Janet said she would challenge the vote. The vice president said that was her right. The vote took 15 minutes. 3 residents were nominated and elected by show of hands. Janet did not vote. The new board members took seats at the table. The vice president said the first order of business was to remove Janet from her role as interim treasurer and social committee chair, effective immediately. He called for a vote. All 3 new members voted yes. Janet stood and said the vote was retaliatory and she would sue. The vice president said the vote was based on the evidence presented and the board would cooperate fully with any investigation. Janet gathered her portfolio and walked out. The room was silent for a moment, then someone started clapping. The applause spread. I stayed in my seat. After the meeting, the vice president asked if I would be willing to work with the forensic accountant as a witness. I said yes. He also said the board would be reviewing all violations issued in the past year, and any that were found to be improper would be expunged and refunded. I thanked him. He said I had done the complex a favor, and he was sorry it had taken so long. Over the next 2 weeks, the accountant interviewed 6 residents, reviewed the financial records, and subpoenaed bank statements from the HOA's accounts. On February 24th, the report was posted. It confirmed $19,000 in fraudulent payments, all approved by Janet, with evidence suggesting the funds had been transferred to accounts controlled by her or her associates. The report recommended criminal referral and immediate restitution. The board voted unanimously to file a police report and to begin legal action to recover the funds. Janet was banned from all HOA property pending the investigation. On March 5th, I got a call from a Redmond police detective. He said Janet had been charged with theft and fraud, and the case was moving forward. He said my evidence had been critical, and he might need me to testify if the case went to trial. I said I would be available. He thanked me and hung up. At work, my probation ended on March 15th. My supervisor said I had done excellent work and she was moving me to full-time with benefits. I thanked her and did not mention the HOA. The complex is quieter now. The new board installed clear violation procedures, posted all financial records online, and hired a third-party management company to handle enforcement. The boot mat is still on my porch. The camera is still recording. Janet's unit went up for sale in April and she moved out in May. I heard she took a plea deal and paid restitution, but I never followed up. The Mailbox cluster is still the neighborhood gathering spot, and people still talk about the night the board collapsed. I check my camera footage once a week, but I have not needed it. The winter is over, the ice is gone, and the only thing I scrape off my porch now is the occasional delivery box. The complex is not perfect, but it is fair, and that is all I ever wanted.